So I am now about to cover the coronavirus. So I'll just launch my screen up ready for you and get that on the move. There we go, ready to go. So for anybody who doesn't know me, my name is Hayley Mason and I am Senior Solicitor and Director at SEN Legal. Anyone who follows our social media, you've probably engaged with me at some point because it's me that goes on there and rants all over Twitter when I see unlawful things happening to parents to warn you so it doesn't happen to the rest of you. So you'll probably be familiar with me from that means, or you might be familiar with me from my friends over at Specialised Jungle because I blog for them on a regular basis as well. So we are going to be talking today about coronavirus and where are we now? Obviously, coronavirus has come in and impacted all of our lives in ways that we would never have imagined this time last year. And unfortunately, it's children's legal rights that have been hit. So I want to talk to you about what it actually means for you and to make sure that you are not taken advantage of by your local authority. So there were two key changes that came into force on the 1st of May 2020. And 1st of May 2020 was a Friday, and on Thursday, the 30th of April, this is when they were announced. So there was a flurry of activity in the SEN world as these two key documents launched. While we were, they didn't come out of the blue, we were expecting them. They had been kind of talked about since the 23rd of March when we originally went into lockdown. But as time went on, and obviously we went through April, we didn't necessarily think nothing was going to come in because we hadn't heard anything. And lo and behold, on the 30th of April, these two key changes came into force. So we have two different sets here, and I'm going to talk about them separately because they apply to different people. So we've got the timescales, which affect all EHCP processes. So what James was talking about this morning, the assessments, the ability to finalise the EHC plan, the draft EHC plan, going through the EHC assessment, all of those timescales, they're all encapsulated in the first section that I'll be talking about. And then the second section that I'm going to be talking about is the temporary amendment to the duty to provide provision under section 42. And in non-legal speak, that means for children with EHC plans. So the first section is for everybody involved in EHCP processes generally, and the second section is for those who already have an EHC plan. Unfortunately, when these were brought into force completely out of the blue on the 30th of April, there was no impact statement and no time between the documents being issued. It was about 3 p.m. in the afternoon, one got issued and then the next one got issued straight away. And therefore parents and professionals alike had very little time to adjust. I fully appreciate parents in this world. You are juggling so many different balls at any one time. How you were expected to pick up these two documents and analyse them and work out exactly what it meant for you before the next day is just, you never expected to work that out. And it was very unfair the way that it was done. But I hope I can guide you through it now. So the first one is the timescales, the new Special Educational Needs and Disability Coronavirus Amendment Regulations, so a big mouthful. The new regulations temporarily amend the regulations that we're more familiar with, which is the Special Educational Needs and Disability Regulations. So they're the normal regulations and these are what amend those timeframes. Prior to the release of the amendment regulations, there were a lot of uncertainty about what should be done and when, because when the COVID-19 came in, obviously parents didn't know what timescales that they should be following because there was lots of misinformation from everybody right across England and Wales. Local authorities at that time remained under an absolute duty to meet the various deadlines required under the regulations or face judicial review proceedings for failing to do so. The reality is, and I'm sure I don't need to tell parents this because you're stuck in the thick of it, local authorities weren't good at meeting deadlines anyway, let alone before coronavirus happened. So when they had suddenly reduced staffing levels and obviously a pandemic, that only made the situation worse. So these amended regulations came into force on the 1st of May and they're currently set to last until the 25th of September. So the timescales James talked about this morning, that is generally in the SEN world that will apply after the 25th of September. And this is just what's applying only in the interim period while there's coronavirus obviously surrounding us. From the 1st of May, the processes themselves remained unchanged and parents and institutions can still submit EHC needs assessment requests as normal. I saw lots of unlawful information coming out when this was first announced, where local authorities were saying we're suspending EHC plans, we're not going to be complying with anything, we're not going to be performing EHC needs assessments, we're not going to be issuing draft EHC plans. All of that is completely unlawful. The only thing that has changed is the timescale by which the local authority have to do these things, and not the actual things themselves. So please don't try to write all of this down, because obviously there's lots and lots of information on this slide. I've essentially just covered all of the timescales that are affected by these new amendment regulations, and in a nutshell, the timescales affected are essentially all of the timescales in relation to EHC needs assessment processes. So transferring of plans between local authorities, mediation, draft EHC plans being issued, final EHC plans being issued, decisions whether to assess, essentially everything. And I've just put it on a slide there, so when you go back to this slide, you can have a look and see if yours is obviously included. There are two different also types of wording depending on where your regulation fits. And this is kind of a very legal thing, but essentially what I need to tell you is whichever wording applies to the situation that you are in, because it depends which part of the regulations as to which timescales apply, wherever you are, whichever set of wording is going to ensue. Where prior to these new regulations, there were specific time limits, so the 6 weeks to make a decision, the 10 weeks to perform the EHC needs assessment, the 2 weeks to issue a final EHC plan after receiving the draft. I know parents are looking at me and saying, Hayley, those timeframes are really not realistic, but I'm talking about the legal timeframes that your local authorities should be doing and must normally be doing, and actually not what they do, I know practically on a day-to-day level. So what happened with these new regulations is actually, rather than those specific timeframes, this changes it to as soon as reasonably practicable. So local authorities will get around providing decisions late as long as it's reasonably practical and due to coronavirus. This is really important. As you can see here, where the coronavirus exemption applies, as soon as reasonably practicable. And I won't read all of the slides out for you, but again, the local authority need not comply with the time limit for a reason relating to the instance or transmission of coronavirus. It's really, really important, because I think what is happening, and I can see happening on social media, is local authorities just saying, brilliant, excellent, excuse to sit back, not do anything, we don't have to send any decisions out. That's not the case. If things are happening normally in local authorities, or if they have the ability to get decisions out on time, they should still be doing so. And the only exemption which requires it to be reasonably practicable instead is for reasons relating to coronavirus. It's very, very clear. This is just not an excuse to sit back and do nothing, and local authorities will be challenged if they try to do that. So key points, what do you need to take away from this amendment to the timescales? The actual processes must continue. And again, I say that again because this is something that I've already seen misapplied on social media, and I know parents are struggling with in England and Wales. The new regulations and guidance are clear that they only apply to timescales and that the EHC processes remain in place. The guidance issued by the government, the Education, Health and Care Needs Assessments and Plans Guidance on Temporary Legislative Changes Relating to Coronavirus, which was issued on the 30th of April and updated on the 29th of May, clearly states, this guidance also confirms which key elements of the processes over EHC needs assessments and plans are unchanged. Notably, this includes that a local authority must still consider requests for new EHC needs assessments, must still secure all of the required advice and information in order to issue a plan, and must have regard to the views and wishes of a child, the parent, or a young person when considering its SEND functions under the Children and Families Act. So there is no getting away from this. And if your local authority is saying that they're suspending your EHC plan, they're not issuing an EHC plan, they're not providing you with a decision, all of that is unlawful. And please, please do challenge it, because you're in the legal right atmosphere. You're within your legal rights to actually challenge that. So please, please do so. So I really want to make that clear for parents. Failure to carry out processes will leave local authorities open to judicial review challenges. And I must stress that if a local authority blanket bans and says, actually, we're not doing any EHC needs assessments during this time, that's a judicial review. So please seek legal advice where you need to do so. The second key point about the timescales, the coronavirus exemption only applies, again, where I'm saying it's only not reasonably practicable for a reason relating to the incidence of coronavirus. And I know I'm kind of whittling on about this, but I don't want local authorities to have any other excuse to delay your timescales. Timescales are very, very important because they are what give you your right of appeal if you need to challenge anything. So what you should be asking yourself, and what you should also be asking the local authority, is what is the reason for the delay? If they're saying you're not going to be getting your decision on time and you've been anxiously waiting for your decision, because I know as soon as you have a certain date to work towards, parents are, they're marking off that date in their diary, they're counting down to that date, and it gets here, where's your decision? And then you end up in this minefield of, well, when am I going to get it? Well, when am I going to get it? What you should be asking there is, what is the reason for the delay? And I've just put a note on here because if you're in an EHC needs assessment, it might be quite easy to satisfy this requirement because you might have medical professionals who are being diverted to the NHS frontline to deal with coronavirus. And understandably, they may not be able to assess during that time frame. So EHC needs assessment requests, I can see how that could happen. If, however, you have a draft EHC plan, you've provided your comments on that draft EHC plan and you're simply waiting for your final EHC plan to be issued to give you your right of appeal if you need to use it, that exception doesn't really apply because the only person you're waiting for is an SEN case officer. So unless the SEN team, the whole team is struck down by coronavirus, there's not really an excuse there. So if you think your local authority are pulling a fast one, please do seek legal advice and seek some advice because actually that's not where this transmission of coronavirus exemption would apply, and the temporary amendment wouldn't apply and the normal timescales would apply there. So please be asking yourself, what is the reason for the delay? Thirdly, if you had a deadline, such as the end of the 20-week timetable to issue a final EHC plan, which passed before the 1st of May, so these amended regulations only came in on the 30th, on the 1st of May. If you had any decisions due before that time, the amendment regulations were not in force and therefore do not apply for you. So if you had, for example, in January requested an EHC needs assessment and they had 6 weeks to respond, and they didn't do so, and your deadline would have been middle of February, you can judicially review for that decision. So please look at when your timescales were required, because what lots of parents I think have done is thought, oh, it's all been changed and now I'm never going to get my decision. That's what happened. When I jumped onto social media, onto Instagram and started talking about these timescales, lots of parents wrote back to me saying, oh, well, I haven't had mine for 50 weeks, now I'm not going to get it for much longer. Please enforce your parents' rights. This is one of the only areas of law where it is solely reliant on parents enforcing your legal rights. Nobody is going to do it for you. And I know it's a battle. I know it's an absolute battle for parents that are already dealing with so much, but local authorities are not going to give you a decision off their own back. So you need to challenge them. So look when your original deadline was due, and it's before the 1st of May, you can still get it now. And we can judicially review through pre-action protocol procedure to get that decision for you. So for anyone who thought that they'd completely lost hope about this and there was no way forward, I hope that provides you with some recourse there. Appeals in respect of refusal to assess appeals and refusals to issue against the content of issued plans, including national trial cases, which Jennifer will talk about later, and cease to maintain appeals can still be lodged with the tribunal with the normal statutory timeframes. I think what happened is because this changes all of the timeframes for EHC needs assessments and processes, lots of parents suddenly got confused that actually if they were in a tribunal, all of their timescales were also going to be amended. That's not the case. The first tier tribunal has already put in place measures to provide business as usual by holding case management hearings and appeals by telephone and video. In fact, they're one of the only courts to be fully operating during this pandemic. And John's going to talk to you a little bit later on about digital hearings, and he's going to be covering all of that. But these timeframes are different. So if you're in the SEN tribunal, if you've lodged an appeal and you've got your set procedure rules, so you've got your 4 weeks for the response, 8 weeks for evidence, 12 weeks for a hearing, they are not affected by these amendment regulations. These are just EHCP processes. So I just wanted to make that clear, and please don't confuse the two, because I think there were some confusion about parents when this was initially announced. Equally, however, this should last until the 25th of September as it currently stands. If there is evidence that the effects of coronavirus will last beyond the 25th of September, then it is possible to extend the period in which the amendment regulations are in force. obviously as parents, we do not want that to happen. So we will be advocating to really try and push back against the government to make sure that these are not extended beyond the 25th of September. And I know that my friends over at Specialised Jungle are doing some fantastic work in really trying to force that doesn't happen. At the moment, we do not know whether the amendment regulations will continue beyond September, but I would expect that due to the LAs needing to transition children back into schools and any excuse to delay, they will try and push them back. So as parents, we need to keep pushing back against that to make sure that these are not extended beyond September. You also have to remember, if we have low infection rates that the government has started to talk about, children going back to schools and some form of normality resuming by September, it's going to be very difficult for the government to find justification to extend these timeframes. So as things return to some kind of what we would consider normal, then obviously there will be a real lack of excuse as to why these need to be amended further. But at the moment, they're in force till 25th of September, and I will obviously keep you updated. The next amendment that came in was the duty to provide provision under Section 42, where provisions were temporarily relaxed. So anybody who follows me on social media will know when the pandemic started, I opened up questions from parents through Specialised Jungle. We had over 200 parents come back to us with lots and lots of questions. And some of the questions kind of related to, my daughter is 18 with an EHC plan. She has a mentor, she has speech and language sessions, she has a one-to-one. Should she be seeing these people outside of school or college? If schools close, can I deliver speech and language therapy sessions to my children using an independent speech and language therapist? Can my ABA program, which is funded for an EHC plan, be carried out in my home? And it was evident from all of these questions, they were coming in thick and fast, that the global pandemic brought about a number of concerns for parents about how their children are going to be properly supported, which is what instigated this change in the law under Section 42. So the key document that was issued was a notice to temporarily modify Section 42. And Section 42 is the absolute duty on a local authority to provide the provision in Section F of a child's EHC plan. This modification duty removes that absolute duty and changes it to a reasonable endeavours duty. And I'll go through what that might look like for your child. The notice can only be issued for 1 month at a time. So it was originally issued on the 30th of April for the 1st of May, lasting till the end of May. Then what happened is at the end of May, the 29th of May, they actually then issued a new notice for June. So there's currently a notice in place from the 1st to the 30th of June. So at the moment, it's going to last till the 30th of June. It may last longer, but they can only be issued for a month at a time. So towards the end of the month, you should look out for a new notice, or follow me on social media and follow SEN Legal, and obviously we'll tell you if the notice is there. But this time they were very blessed with their timing, and they let us know at 4:45 on a Friday afternoon for the notice to come into force on the Monday morning. So they really do not give you enough a notice, particularly when you're trying to juggle so much already. The justification given by the government was that while children with EHC plans obviously are entitled to attend school, many parents face significant pressures not to send their children to school. And given that school would be virtually, all classes would be different, even if children were going in with changes to routines, staff, class groups, and often cohort, many children's needs prohibited them being able to attend without extreme distress. And therefore that left parents at home doing their very best to meet their child's needs with little or nothing by way of external support and provision. So there was this absolute duty that nobody could actually comply with, because lots of children obviously were not going into school. And the position was at that time that key workers and children with EHC plans could still go into school, but obviously it was looking very different for them. So rather than that absolute duty, what this done is that they changed that from an absolute duty to being it would be discharged as long as the local authority had used reasonable endeavours to deliver the provision. While the Coronavirus Act also allowed for a temporary reduction to Section 43 and Section 44, so conducting annual reviews and also duty on schools to admit children, those powers have not been enforced. So if your local authority is saying that they're not going to be conducting an annual review of your child's EHC plan, that's unlawful. They haven't instigated that in the notice. So all annual reviews should be going ahead as normal. But as I just previously said, because of the timescales, there will be a delay to the 4-week decision for an annual review. You have your annual review, 4 weeks later you get a decision, that may be delayed, but the actual annual review should still be going ahead. So it then came about as to, okay, local authorities just have to use reasonable endeavours. What does that mean? Your local authority cannot do nothing. While there is no legal definition of what reasonable endeavours looks like, and that's the stress for parents. What is a reasonable endeavour? What might that look like for my child? And local authorities using this as an example to go, you know what, they're your children, you go home, you parent them, you homeschool them, you do the therapy, you do all the care. You know, they expect you to be juggling so many things at once, and it's not possible. So if your child does have an EHC plan, and there is provision set out in section F of that EHC plan, you should be forcing the school and the local authority to provide as much of that as possible when you're at home. And I know parents are really struggling because they feel like sometimes they're a burden and they're just banging their head against a brick wall, but you cannot do everything. You cannot be parent and feeding and watering and doing everything else at home and homeschooling and therapies. It's just simply impossible. So you need to ask for help, and you need to force your schools and local authorities to provide this help for you by this way of reasonable endeavours. So these, what I've included on these slides, are 3 slides, and I'll kind of gradually go through them. This is what is set out as comprehensive examples in the government guidance of what existing good practice of alternative arrangements look like. So there are just some examples, and the list is intended to be illustrative, but not a comprehensive list of possible arrangements. So I would urge all parents to actually speak to their school, speak to their local authority, and actually think creatively and flexibly as to how Section F of your HC plan can be delivered. So if your child, for example, receives speech and language therapy at school, and that's not possible at the moment due to coronavirus, will that speech and language therapist deliver speech and language therapy by Zoom or by Microsoft Teams or similar? If that speech and language therapist won't, is there an independent speech and language therapist who's willing to do so? I know many independent speech and language therapists who are doing lots of virtual sessions with parents and children, and actually the funding for that then can be sent to the local authority. So there are lots of options. So there's just a few that I've listed on here. We've also got some more here. So again, as I've just said, a speech and language therapist delivering sessions via video link. We've got occupational therapy and physiotherapy, again, being delivered by video link, or perhaps the occupational therapist can talk the parent through how to do some of the activities, how to do some of the exercises. And again, I say here, if you are struggling with regulation at home, please do familiarise yourself with those expert resources on our website. The expert resources tab on our website has been added to by all of the experts that we work with regularly. They're very esteemed in their areas, and they've recorded short videos for you while you're at home with your children during COVID-19. So actually, if you're looking for some speech and language games to do with your children, Unit Hurley's provided something on there. There's something about easing anxiety from amnesia of law. There's proprioceptive feedback and how to deal with some sensory processing difficulties while you're at home with Linda Erickson. So please familiarise yourself with those free resources and really utilise them and see what might work for you and your child. Because if some of those activities work, then actually you can feed back to the school, this is really working for me and my child. This is what we should be putting in place. Again, there's some more examples here. So where an EHC plan already includes a personal budget or direct payment, widening its use to enable the purchase of equipment or other relative support home learning, exercise sessions by video. If you've got an ABA program that's fully enforced at home, then at school, then it can be enforced at home. And what I've seen local authorities doing for my clients who have ABA programs in place is what they are doing is they're actually providing a personal budget to the parents for the parents to pay for the ABA program at the moment. So just bear that in mind, that there are options, and we really do need to be thinking flexibly and creatively. So key points about this duty to provide provision, and what I really need to summarise and make you aware of. EHC plans will remain in force. This is absolutely key, because I think, again, lots of misinformation was put out there to parents that suddenly their EHC plans might for some reason lose their legal status, which is completely not the case. Also, parents were concerned, and I know lots of you will be nervous, that if you accept lesser provision, or if you accept some amended form of provision while this is going on, in fact, that when you go back to school, they're going to take that provision away that you've normally got in the plan. They cannot do that. That is unlawful. So please do not be concerned that if you accept an amendment now, that's going to go in force when your children go back to school. That's certainly not what's happening. Annual reviews, again, as I've said, will be continued to run by flexible means. They are taking place via video link. I've attended many for my clients, and they seem to be working quite well. And obviously it allows parents to obviously still follow the timescales, talk about any amendments that are needed to the plan when the children go back to school. Not now. Now is just an unusual time for everybody, and you don't need to amend your EHC plan now. You just need to use the reasonable endeavours amendments now. Do not change your EHC plan, and your EHC plan will continue when your children go back to school. Do not let local authorities use this as an opportunity to take provision out of your child's EHC plan. Please do not do that. Schools must continue to admit pupils under Section 43, and local authorities cannot use this as an excuse not to do anything. I know from my time on social media, my time working with Special Needs Jungle, my time working at SEN Legal, parents are a force to be reckoned with. And actually, you are, more persuasive and defiant than any other group of people. So you really, really need to push back against your local authorities if they're saying they're not going to do anything. The current public health crisis will leave no aspects of our lives untouched. We know that for sure. The care and support which children and young people ordinarily receive will be hugely disrupted, and I can understand wholeheartedly why this worries parents. The global emergency calls for open minds and collaboration about how we can creatively deliver provision more than ever to ensure that children and young people with special educational needs can continue to get the care and support that they need. I know collaboration with your local authorities is not easy. You do not have to tell me that, because I fight them daily. That is my full-time job, to fight local authorities to get your children's rights enforced through their EHC plans. So I know it is not an easy task. But if you're getting nowhere with your local authority, speak to the school. Perhaps the school have got some examples. If the school have got equipment that they can send home, they should be sending laptops home. They should be sending OT equipment home. Does your child have a special chair at school that perhaps they need at home now? Does your child have a writing slant? Do they have specialist tables, an adaptable table? Anything that's physically possible to go at home to support your child at home should be going home. And the therapy should continue to be delivered. So there is now a requirement. The local authorities and schools need to be very creative. And if you go to your local authority and say, actually, this is what my child receives in their EHC plan, they currently can't get that, but I found this creative way of delivering it, they will have to give you that, because it's going to be very, very difficult for them to defend an argument that actually that's not reasonable to do, particularly if it requires them to do nothing other than fund it. So please make sure that you're thinking creatively, you're working with the school as much as you're able to, and listen to parents and other ideas that people are doing, because lots of people are being really creative in this time. So I'd really advise you do listen to all of the options and think flexibly. If local authorities can continue to secure or arrange the provision exactly as it is set out in Section F of the EHC plan, they must continue to do so. This is really, really important. Some children will still be going into school, and I know this is a very grey area for parents. Parents are very, very worried about sending their children into school, and I completely understand. I'd advise you all to be kind with each other about that, because everybody's situation is different. We may have parents at home who it was absolutely fine for the first week, and those parents are now struggling. That is completely understandable, and they should not feel that they cannot send their children in because they can't cope with their needs at home. Parents are dealing with a lot, so if you need to send your child back into school, please do so. If they've got an EHC plan, you can send them back in as a right, and if their school is not specifically open at the moment, your local authority has to provide a school for them to attend. So if you're a parent who's struggling at home, send your child back into school. If you're a parent who doesn't want your child to go back into school because actually you're getting on a bit better at home and you're feeling much more comfortable at home, my colleague Nicole Lee is going to cover this in her session about education other than at school. Perhaps that's something you might want to think about. But the last thing we want to be doing as parents and as parent representatives is turning on each other, because everybody's situation is different. So please just be kind with one another. And if you're sending your child back into school or not sending your child back into school, all of these sessions are tailored around those two different things and how you can work for your individual situation. So please just make sure we're fully supporting each other, because that's what we need to do. There is enough people against you in this world to obviously be against one another. Lastly, I just wanted to touch on the fact that the issue of funding should not be an excuse to refuse a modified delivery of Section F of an EHC plan. Schools and colleges will continue to receive their usual funding, including from the high needs block, to support them through this period of disruption. The government have been very, very clear on that. There is clear guidance as well. So schools and any other establishments will be receiving their normal funding. So that's even more of an argument why they cannot refuse reasonable endeavours. So in fact, they must do so. And if anything can be carried out as it normally would, using the corrective PPE and safeguarding, then in fact that should happen. So it's only where the modification is only applying where that is not possible and only due to coronavirus. I've just popped up here some details. Obviously, as I've already said at the beginning of this presentation, I do not do legal aid work. Unfortunately, we don't have a legal aid contract. We are privately funded by parents. In the tea break and in the lunch break, we are circulating details of two fantastic bodies, SNJ, which is a parent group that I regularly blog for, completely free of charge. And also they do lots of webinars to help parents, and also HACS. HACS are a fantastic charity who again do lots and lots of webinars and support parents who perhaps can't afford legal representation to go through these processes. So if you can't afford legal help, then please do contact them. And obviously if you can afford legal help, these are our details here. You can follow us on social media, try and really utilize lots of the free resources we put out there. We put it out there for parents to be able to be aware of their children's rights. So without further ado, I'm going to pass over to one of my fantastic colleagues, Alice. She is a barrister at 3PB Buildings. She is an expert in exclusion. So whether you're sending your child into school or not sending your child into school, Alice definitely has you covered. So please keep your ears peeled, and I will hand over to Alice for her fantastic presentation next. Thank you all.